Hello, government students. Today we will be starting Unit 4, which is on the judicial branch. Today we're going to be taking notes 4.1. Your essential question: what is the judicial branch and what powers do they have? So first we're going to be learning about the national judiciary, the article of the Constitution that created it, how federal judges are appointed, what their benefits are, and what roles they play. Remember, this was created in Article 3 of the Constitution, the judicial branch. Article 1 of the Constitution established our legislative branch. Article 2 established our executive branch, and then Article 3 established our judiciary branch. So there's two court systems in the United States. We have the national judiciary that spans the entire country, and then we also have court systems run in each of the 50 states. The Constitution created the Supreme Court and then left it up to Congress to establish all the inferior courts, which are the lower courts. So there are two types of federal courts: the constitutional courts and the special courts. And we're going to go into detail about what those are. So here on this graphic, you can see the constitutional courts here on the left. So those are the district courts, the Court of Appeals, the courts about trade, whereas we have special courts regarding specific things like taxes. We have a U.S. tax court, so any cases involving taxes, they go there. Any claims over territory, they go to the territorial courts. We have courts of the armed forces, so if you're in the military, they have their own special courts as well. Jurisdiction is defined as the authority of a court to hear a case. To hear a case means to have a trial, to try a case, and then have a decision at the end of that case, to have the trial, to try and decide a case. Our Constitution, Article 3, Section 2 says that federal courts can hear a case because of the subject matter of the case or because of the people that are involved in the case. There are two types of concurrent jurisdiction. Remember, concurrent means two things happening at the same time. So some cases can only be heard in federal courts. In that case, the federal court would then have exclusive jurisdiction. So that means they're the only one can hear it. But the concurrent ones are ones that can be tried in a federal court or a state court. So if we have a court case that can be tried in either one, that is considered to have concurrent jurisdiction. Original and appellate jurisdiction. A court in which a case is first heard can have original jurisdiction over that case. So they're the ones that first hear it, so they have the original jurisdiction. A court that hears a case that's been appealed. So that means if you have a trial for the case, you don't like the outcome, and you want to appeal it to a higher court, that would then go to an appellate jurisdiction court. So Supreme Court exercises both original and appellate jurisdiction. So if a court goes to the Supreme Court, or if a case, goes to the Supreme Court, it can either be a case that was appealed up all the way to the Supreme Court, or it can be a case that starts originally in the Supreme Court. The power to appoint judges to the federal courts falls on the president. The president gets to nominate the Supreme Court justices, and then it goes to the Senate for them to have a hearing and confirm that nomination. Most federal judges are chosen by being an attorney prior to being on the Supreme Court, being a law school professor. Ruth Bader Ginsburg, remember, was a law professor, and then she was an acting lawyer as well. Former members of Congress, people who work in the state courts, all of those people are generally the people that are chosen to be a Supreme Court justice. But these cases can be very controversial. So in the 90s, we had a lot of controversy picking a Supreme Court justice in 1991 with President H.W. Bush, the first President Bush. He nominated Clarence Thomas to the Supreme Court, but during his hearing, when they were investigating him, deciding whether he would be a good fit on the Supreme Court, this woman who used to work with him, Anita Hill, had accused him of sexual harassment in a former job. So she went in front of Congress, and she testified and told them about his prior sexual harassment in the workplace. That did not prevent them from still appointing him as a Supreme Court justice. More recently, just in 2018, we had a lot of controversy as well. President Trump nominated Brett Kavanaugh to the Supreme Court. Brett Kavanaugh was also accused of sexual assault. Dr. Blasey Ford here on the left, she accused Kavanaugh of sexual assault when they were younger. Brett Kavanaugh denied this sexual assault, and it was very contentious. A lot of people were protesting, saying that someone who has committed sexual assault shouldn't be on the Supreme Court. And Brett Kavanaugh was very upset about being accused of this. As you can see in this picture here, people were yelling, crying. It was quite a scene for a Supreme Court nomination. But he did get approved as well. The Republicans controlled the Senate, so they were able to confirm President Trump's nomination, and Brett Kavanaugh currently sits on the Supreme Court. Judges are appointed to the constitutional courts, and the Supreme Court, they are appointed for life, so they get to serve life terms. So they can either serve up until they die, like what just happened last week with Ruth Bader Ginsburg, or they can work until they want to retire. If they choose to retire at a younger age before they die, they can do that as well. Judges of constitutional courts can only be removed by their own will if they resign or through impeachment. So just like the president can be removed through impeachment, justices on the Supreme Court can also be removed by impeachment. 13 federal judges have been impeached in the history of the United States, so it's very rare, it doesn't happen very often. And of those 13 that were impeached, only 7 of them were actually convicted of their crime. Now, the inferior courts are the district courts. So we have 94 federal judicial districts across the United States. So we have at least one for each state, and then we have one in DC and one in Puerto Rico as well. So larger states are divided into 2 or more districts. You can see here as an example, Florida, each one of these different colors is a different district. And smaller states potentially only have 1 district if they are much smaller, like Rhode Island. District courts have original jurisdiction in most cases. These are any federal issues, they go to the district courts first. They can hear both criminal cases and civil cases. A criminal case in the federal courts is one in which a defendant is tried for committing some sort of crime, so committing some action that's declared to be a crime, whereas a civil case, on the other hand, handles non-criminal matters, so these are more personal lawsuits, liability cases, things like that. The Court of Appeals were created to handle the burden that the Supreme Court faced originally for appealing cases. So they only have appellate jurisdiction. So that means they only will ever hear a case if the case has been appealed, meaning they already had a trial once, and the people who were not the winners of that trial then appealed to a higher court. So this graphic here kind of shows you how things can be appealed in the federal court system. They can be appealed all the way up to the Supreme Court as well. And the Supreme Court also has original jurisdiction, so it doesn't necessarily need to be appealed to get to the Supreme Court. We also have courts of international trade, courts of federal claims, courts of veterans claims, to focus on those specific issues. Right now, the Supreme Court specifically has 9 members. They all meet here in this building. This is the Supreme Court building in Washington, D.C., where all of these cases are heard. Judicial review refers to the power of a court to determine the constitutionality of a government law or action. So remember, the first branch, Article 1, established the legislative branch that writes the laws. They pass it over to the president. Article 2, the executive branch, they then get to sign that bill into law. They get to create that bill. They get to create the law from the bill, and they get to make sure that it's enforced. And then Article 3 establishes our judicial branch, and our judicial branch gets to say whether that law is constitutional or not. So they get to determine whether that law should still be a law or whether they should scrap the entire thing. The Supreme Court first asserted this power of judicial review way back in Marbury v. Madison in 1803. So the court does have original jurisdiction in any case that involves two or more states. So if two or more states brings up a case against the United States, then they go directly to the Supreme Court. But most of the cases that are heard by the Supreme Court are appeals. So that is when, as we've discussed earlier in these notes, when someone doesn't like the outcome of an original trial, so they appeal it up to the Supreme Court. For a case to be heard by the court, 4 of the 9 judges must agree that it should be placed on the court's docket. The court can obviously only hear so many cases per year, so they have to decide which cases they are going to hear during their term. So as long as 4 out of the 9 of them agree, it will be placed on their docket. So usually it takes a few appeals to get up to the Supreme Court for the Supreme Court to hear a case. Now, the Supreme Court also doesn't have to hear a case. If someone appeals to the Supreme Court and the Supreme Court doesn't get more than 4 of these justices, then it can be sent down. So it can be sent back to the lower court and they can tell the lower court to reconsider it again, or they can allow the lower court ruling to stand. They can say, no, we agree with the decision that was made at the lower court, so we will not hear this case. Or they can choose again to hear the case. So once the Supreme Court does decide to accept a case, it sets a date on which the lawyers on both sides will present their oral arguments. So these are their defenses in court. They have to write briefs. Briefs are written documents that are filed with the court before the oral arguments begin. This gives them information about what both sides are going to say, what the argument is, what the basis of the court case is about. And the court in conference. So then the Chief Justice presides over a closed-door conference in which all 9 justices present their views on the case at hand. Once the court has finished the conference, it then has to reach a decision and an opinion is written. It only has to create a decision by a simple majority. So remember, there's 9 members, so just 5 have to agree for it to get passed. So if 5 agree, we have a majority opinion here. This is officially called by the opinion of the court. It announces the court's decision and its reasoning on which it's based. These set precedents, so these are examples for lower cases and lower courts to follow in the future. Concurring opinions, if someone would like, let's say 5 Supreme Court justices agree on an issue, like in 2015, they agreed on same-sex marriage. They said that marriage equality is the law among the land, it's against the 14th Amendment, that equal protection clause that Ruth Bader Ginsburg taught us about. It's against that to deny the right to marry for any citizen of the United States who is a consenting adult. So if someone wanted to agree with that, they just wanted to share their opinion and why they agreed with it, they could file a concurring opinion. So this is just emphasizing the point on why this decision was made. But if someone disagreed with the majority decision of the court, they could file a dissenting opinion. These are written by justices who do not agree with the majority, and they would tell us why they didn't agree with the majority. So like Ruth Bader Ginsburg in her documentary, remember we learned that she filed a dissent in the Lilly Ledbetter case. So she told Congress that the ball is in your court now, that we obviously have a case where we have discriminated against women, we have paid them less than men, and this needs to be rectified. The Supreme Court disagreed, so she wrote a dissent that she did not agree with the majority opinion, but then she sent it to Congress for Congress to create a new piece of legislation to rectify that. So this is our current Supreme Court. Each court is titled by whoever the Chief Justice is. So we call this the Roberts Court because right here in the middle is the Chief Justice. He is the person in charge of the Supreme Court, Chief Justice John Roberts. And this last slide here is just a breakdown of our Supreme Court right now in 2020. So the Supreme Court is very relevant to what we're learning about right now because we just lost Justice Ruth Bader Ginsburg last week. So because we lost Justice Ruth Bader Ginsburg, we now have a vacancy on the Supreme Court. We have 5 members over here that are on the conservative block. As you can see, there are these gentlemen right up here. And we have 3 members over here on the more liberal block, the more democratic block. So if President Trump gets to, which he might not, but it looks like he probably will get to decide another Supreme Court justice. He wants to have a Supreme Court justice that does not agree with women's right to abortion, that is much more conservative. So it looks like this will be a larger majority. We will have a 6-3 majority with conservatives over liberals. And I put the ages next to them as well, just so you could kind of see the ages of all of these Supreme Court justices and why it's always important to pay attention to these when we make our votes for president. Um, a lot of people weren't really paying attention to this in 2016 when we were having our election between Donald Trump and Hillary Clinton. But if you look at some of these ages, RBG, who was 87 when she just passed away, Stephen Breyer's 82. So if he's 82 right now, if we elect another conservative president, that means that this person, 4 years from now, they will be 86 years old. So 4 years from now, if they make it that long, hopefully, knock on wood, we don't wish anyone ill will. But if Stephen Breyer doesn't make it on the Supreme Court until 86 years old, he could be also replaced by another conservative president. So this could not only go 6-3, it could go 7-2. So we really have to think about the Supreme Court when we make our decisions for president, because the president, remember, does get to choose who they want to nominate for the Supreme Court. All right, and that's the end of your notes, everyone. So don't forget to write a summary, notes 4.1.